Graham.
Thank you. Can I refer you to your Rule 8 response, your inquiry statement, paragraph 339, please?
With respect, ma'am, I don't think it goes up
It's
as
not
far
that
as
one.
that.
It doesn't go up that far. It doesn't matter. I must have made a mistake there. As I understand the position, the PIRC report belongs to the Crown.
Yes.
And it cannot be shared with anyone else by PIRC without permission of the Crown.
Correct.
I'm interested if you have any views on the ability of Police Scotland to learn about areas where maybe they could have done better. So as a way of sharing, they would need to see the PIRC report, obviously,
Yes.
but there might be learning opportunities for Police Scotland from that. I wondered if you had any thoughts you'd like to share with the Chair.
That occurs all the time, insofar as if we find an issue that needs addressed and we consider it needs addressed immediately, we will draw that to Crown's attention and ask permission to either share that element or share the report with Crown, with the police. And that does happen on a regular basis, because I don't think that we can wait 2-3 years until the end of a matter if you know that there is something that needs sorted, and it needs sorted as soon as possible. So we do go and approach Crown and say, come across this, we think policy, procedure or practice needs to be changed, and it needs to be changed as soon as possible, and we will ask Crown to share it. Sometimes what will happen is Crown will say, yes, well, you can share it, but not the full report. So we'll provide a summary of the relevant area, send it to Crown. But as I think, as I've touched on, before we can make the disclosure, we need a section 44(6) permission from Crown.
Was there anything like that in connection with this PIRC report?
No. Not in respect of the bio investigation. We have done it in other investigations. Crown, of course, can consider our report, and without us having to approach them, decide, I think there's issues to be addressed here, and then send the report to Police Scotland without discussing it with ourselves.
Was there any process or consideration given in PIRC to whether the police could learn some lessons from having sight of the PIRC report and maybe speaking to the Crown about that?
I think that's a very difficult one to answer, and with respect, it might be for the inquiry to consider. We send our reports to Crown. If they wanted to share them with Police Scotland, they could have done so. They wouldn't have to come back to us. You'll have read the reports and examined them. And with respect, it might be for the inquiry to decide, well, we think that those matters should have been shared with Police Scotland earlier.
In 2015, was there any sort of formal step and process that was taken by PIRC with regard to that specific question? Should we be asking Crown for permission to disclose this?
In respect of the bio reports?
Just in general, was there any part of a procedure that was followed by PIRC?
Yes, I think that's what I touched on, which if we identify something that needs sorted or addressed, we would approach Crown, draw it to their attention, but equally Crown may decide themselves to share that matter.
So it wasn't automatic, it wasn't automatically done. That was just something that if it appeared to PIRC it might be merited, they would take that extra step.
Yes, and I think I touched upon one example, which was deaths in police cells with constant monitoring of prisoners. We had picked up on areas that we consider improvements should be made, discuss that with Crown and then share it with the police. Because we don't want another death in the same set of circumstances to occur.
Right, thank you. And then equally, it's not available to the public where a man has died. Do you have any views on whether there would be benefit in making your report transparent and available to the public?
So police referred matters can be reported to the public. Crown ones, it's for Crown to decide. Now, it doesn't prevent us saying to Crown, do you think this should be published? But really, Crown have control of that.
All right, thank you. You've mentioned earlier about reflective learning.
Yes.
We've asked other people about lessons learned exercises, a debrief. Do you remember if there was an exercise carried out in relation to this investigation?
No, there wasn't, due to the length of time it took. Because it started in 2015 and we were still undertaking actions up to 2019, so there was no debrief. We have held debriefs in respect of other investigations, but there was none in respect of the bio investigation.
Do you think that's something that would have been of benefit to PIRC in terms of maybe making improvements in the future after 2015?
Yes, as I say, I think reflective learning, where you consider what you've done, and there is always room for improvement. I do consider we did a thorough, effective investigation, but is there room for improvement? Probably, if I'm being frank.
Are there any areas coming to mind in particular?
I deeply regret the breakdown in the relationship between PIRC and the family. The family were rightly, in my opinion, very angry on day one. And that's an area that I deeply regret. It's my own personal opinion.
And looking back now on that matter and the relationship with the family, have you thought that there may be ways that it could be improved, you know, in a similar situation in the future?
I think you've got to let the flows do their job. Most of the time, there is a good relationship between PIRC, directed through our flows towards families to provide them with support. You do get an occasional breakdown. And if we're talking about learning the lessons, well, why did it go wrong, and how do we ensure it doesn't go wrong again?
Well, we may hear further evidence from Mr. Lewis about the
Yes.
involvement of those. Who in PIRC would have been responsible for instigating a lessons learned exercise, or considering what lessons could be and what improvements could be made?
Usually that was either the head of investigations or the director of investigations, where as you're submitting your reports to either Crown or to the police, they would hold debriefs and say, right, let's walk our way through this investigation and see if there are any lessons to be learned.
And is that normally done at the stage where the final report is sent to the Crown?
Yes, it doesn't always happen, and what I would describe as relatively minor or matters that are not complex. I don't think you necessarily need a debrief, but in complex matters, it does provide assistance.
Given the evidence you've given to the inquiry, is it fair to say that this was a complex matter?
Highly complex.
And we've heard that the final report was August 2016.
Yes.
So it would have been either for Ms. Scullion or Mr. Mitchell to consider a debrief or a lessons learned.
Yes, but as I say, we were still undertaking a lot of investigations after the final report, and that didn't finish up until 2019, by which time both of them had retired. I'd taken over as head of investigations, and our work volumes were ever increasing. So we didn't do a debrief. Would it been beneficial? Potentially. Are there lessons to be learned? But Possibly, probably.
Right, thank you. And I think you became head of investigations in 2017.
Yes.
And I think your inquiry statement does mention further requests for information and additional material were being received in October and November 2019.
Yes.
And that included a request in relation to information about Nicole Short's vest
Yes.
and the mark on
Yes.
it. Thank you. Can you give me a moment, please?
Of course, ma'am.
Thank you very much, Mr. McSporran. Thank you. I have no further questions.
Thank you. Are there any Rule 9 applications? Ms. Mitchell? No one else. Mr. McSporran, would you mind withdrawing to the room while I hear a submission?
Of course, my lord.
Yes.
I'm
Yes,
obliged.
Ms. Mitchell.
The first issue I would like to ask this witness about is in relation to his comments when he gave evidence about understanding the rationale as to why the police officers might be told the results of Sheikh Abayo's post-mortem. What was said by this witness was that about his colleague's decision to do that. I understand his rationale. He was trying to break the logjam. This is the only case in which this has occurred because we'll usually not pass that information without Crown's approval. And he also said that part of the rationale was because in the very early days there was a complete lack of understanding as to what had occurred. And I want to... yes,
Give me the
certainly.
reference for that, please.
That is of this witness's evidence at line 15610, and I'm afraid I haven't checked whether or not that was Thursday or Friday, but I will find that out for you if someone could do that. 15610. As the inquiry knows, at the time in question, they had the statement of Ashley Wise, they had a Snapchat video, they had the statement of Kevin Nelson. So it's clear that they had a significant amount of information. The first thing that I would like to ask was, did this witness think to himself, why did the police officers want to know the outcome of the post-mortem be giving a statement? What could be the reason that they won't give statements till the outcome of the post-mortem is known? And I don't think that has been explored. The next issue which is connected with that is the taking of evidence from officers and the post-mortem. Leslie Bole, on day 66 of this inquiry, in her evidence at page 116 and 117, was asked whether or not she would have given officers the outcome of a post-mortem, and also whether or not it would have caused her concern that officers that had failed to give initial accounts or basic facts or operational statements were being given information about the death from the post-mortem on the Monday evening, and also, a month evening, and also they were still looking for that information of the full post-mortem afterwards. And she answers that she wouldn't have agreed to provide information to the officers because they haven't given us a statement. So why would you provide sensitive information in terms of the results of a post-mortem to a witness who hadn't provided a statement? And she answers, what would be your concerns? Have it been that information was to be provided? That's literally the quote. And if it says, if that information was in some way negative to their viewpoint, it might change the way that they would provide their statement. It's just not appropriate. This witness also said that he wouldn't give the pathologist any information that might colour their judgment, that he wouldn't want to put out things in the media in case it might cloud their memory, that an investigation in securing the best evidence, you want to keep that evidence as uncontaminated as possible, and also used the phrase he wouldn't want to be putting ideas into the pathologist's head. So in light of those, what I want to put to him is why in those circumstances was it not the case that PIRC did not see it's completely inappropriate to provide witnesses with the outcome of a post-mortem? And why did he consider it appropriate to be bargaining with witnesses, especially witnesses who were possible suspects in a fatality, particularly where it was clear that a question of the legality of the use of force would be an issue that had to be considered? Further, an investigation in respect of a death in custody must be independent and adequate because the public must have confidence in the state's monopoly of the use of force. And I think this witness and the previous witness highlighted the fact that that the police were in a singular position in that regard, being the people who were entitled to use force where appropriate. And what I want to ask is, does trading with the officers involved in the death of Mr. Bayo in relation to the post-mortem not fundamentally undermine the confidence that the public should have in respect of these matters? In relation to following up inquiries, this witness said, and moving on to the issue of statements that had been taken, this officer said that they investigated, brought in information and then they considered it. This witness, I would respectfully submit, should also be asked, did he consider the changes in evidence from the Mr. Bayo being clearly in possession of a knife to have not a knife something that he should have investigated? There is a document which is COPFS 02781 where the Crown give a detailed instruction in relation to being in possession of a knife and not being in possession of a knife. That was some 18 months later. They clearly thought it was of import and asked them to follow that up. What I would like to know is what the outcome of those inquiries was. Did he consider that Ashley Wise's evidence and the Snapchat showed that the restraint was not in accordance with proper restraint? And if so, why was she not asked further questions?
Sorry, is this still under the same subject?
Yes, it's under the review of statements. He said that he would take in and review all these things. So these are issues that I would like to ask him about. There's another document, COPFS 02436. This is a Crown document which indicates that having viewed the Snapchat video, the Crown are concerned that police officers have given, that raises matters of concerns that there may be a misleading account of events by police officers. Did it cause him the same concern when he reviewed these documents? Did it cause him concern that some officers had said that a female officer was going to be attacked, and after investigation it didn't turn out that there was a basis for this? Did it cause him to give consideration as to why that might be said if it wasn't true? Did, again, on a review of the evidence, he said the reason for him going to the post-mortem was that he had been told by Mr. Ferguson there had been blood in the Sheikh Obayo's ear. When he came to find this out, this was incorrect. Did he speak to Mr. Ferguson about it to ascertain how this could have come about? And then moving on to a separate issue. Was he aware from Peter Benson of the Cybercrime Unit that Sheikh Obayo's phone had been switched on while being in possession of Police Scotland on 2 occasions? There is an inquiry number document, INQ PIRC 03834. This is an
Say that again, please.
there's a PIRC inquiry document 03834, email from Mr. Benson. Could that possibly be brought up? Because the inquiry might wish to see a concern in that regard. It was to ask him whether or not he knew about this report. At 3 lines down, it says, "It would be foolish to fail to mention what seems to have happened when the device was out of our hands and possibly yours," and that appears to be PIRC. If there's a reason for the activity that can be explained, i.e. someone switched it on to look at something, let me know and I can add something in. If I do not mention it in some form, then any future defence examination will attempt to use it to discredit the seizure and examination. They may still at least, but at least we're being upfront. So it's to ask him whether or not he was aware of that and what inquiries he made into the telephone being switched on the 6th of May 2015 at 16:42 and on the 2nd of June 2015 at 11:40 hours and 11:45 hours.
Ms Mitchell, is this a matter that was put in a written application?
I don't think it was put in the written application. We've been getting a lot of disclosure as the hearing is going on, and I'm not sure whether or not these are one of the ones that came at that time or came later, but there certainly have been issues that I've had to raise as a result of not coming upon documents until a later stage or not realising the import of documents until I see later documents. So my apologies if that hasn't been the case, but nevertheless, I think that might be something that ought to be followed up. I'll leave out that next question. In relation to the issue of race, the inquiry will recall that on a previous occasion it refused to allow questioning in relation to the investigation of the 3 police officers who had been found to be sharing racist apps. And I think the understanding at that time of the inquiry was that these related to the public events of an allegation of racist WhatsApps, but this is in fact a different incident, as I think the evidence earlier today showed. It appears from the documentation in this regard that there was difficulty in obtaining the information in relation to these 3 officers' contact with any other officers on shift from Police Scotland, and I would think it might be helpful for the inquiry for this witness to be asked what that difficulty was and how that difficulty was overcome.
So where's the reference to the difficulty?
There are a number of documents where which show communications. I don't have the individual documents, but they're communications between PIRC and Police Scotland talking about the difficulties with data protection and whether or not these should be given over. And they resulted in, I think, a meeting at which Mr McSporran may have been present where these issues were discussed. In relation to the post-mortem, this witness says that he did not discuss the issue of battening to the head with Kellyanne Shearer. Kellyanne Shearer gave evidence on day 53, the 9th of the 5th, 23, where she said that, and she also said in her witness statement, witness number 0003, that she knew there was an issue about blunt force trauma. So if he did not give that information, might it have been the police who attended that gave that information? And further, in respect of the issue of restraint, the inquiry will remember the view of Mr McSporran that he took the view that what the post-mortem says is what it didn't say is that the restraint contributed to the death, and said that what it says is sudden death in a man intoxicated with ecstasy and alpha PVP whilst being restrained. So it didn't say restraint contributed to the death. The first thing I want to ask him about that is, does he know the system in place on a death certificate which is 1A, 1B, 1C and 1D. In particular, that system identifies 1A as the primary cause of death. And so when he said that he did not consider that to be the case, how would he be able to do that in light of the fact that this was a 1A identification? So it's to ask him to explore with him whether or not he understood that. Secondly, having heard what he said about those matters, I won't need to take him to the detail of it, but the post-mortem makes it clear, post-mortem report makes it clear, and that's page 18 of PIRC 01445, that asphyxia was a possible cause. And also, was he aware that in terms of the post-mortem, that blunt force trauma was in fact not ruled out in the primary findings of the post-mortem? And that in fact, what had to be done was that the piece of brain had to be examined, and that was sent away for that to be done. The next thing is something that arose as a result of something the witness said when he was referring to media communications which were being had by the family and the family solicitor on one side, and the Federation and or Police Scotland on the other. And what he said is that he was not there to referee the opposing factions. He says, we are not there to referee between the opposing factions, if you could call it that. And that was on Friday at line 47, 6 to number 10. Firstly, in that regard, there is a document, inquiry number PS 02571, which is an email from Gary McEwen giving instruction to Kate of Media Edinburgh about a proposed media release. And Gary McEwen instructs her that this is the proposed media release that will go to PIRC and Crown for approval prior to us releasing it. So was he aware PIRC were conducting a supervisory role in respect of media releases that were going out by the police? And then on the 14th of May, William Little sent an email to the police, namely Keith Hardy and Stuart Wilson. It's a very short email, and I will just read it. It's an email, I think, from Mr. Little. And it says, "Morning, Keith / Stuart. The PIRC was made aware of this late yesterday afternoon. John McSporran spoke to Mr. Anwar late last night, and it would appear that the thrust of this conference will be to criticise the police officer's decision not to provide statements regarding their involvement." And thereafter it appears that the draft copy, which was supplied to Mr. McSporran, was then supplied via Mr. Little to the police. So my question is asking him why he gave that document to Mr. Little, and was he aware that Mr. Little passed that document to to the police.
I'm sorry, Ms Mitchell, I just didn't understand that at all.
Sorry.
You need to go over that again.
Sorry, so unfortunately I don't have this as a document that I can bring up on the screen, but there is a document on the 14th of May from Mr Little. It's an email to Keith Hardy and Stuart Wilson. And this relates to a family press conference. That's the subject of the matter. Importance high, as it's written. This appears to be an email from Mr Little, from William Little, and it's sent at 07:55 hours in the morning. That email informs the police that the thrust of the press conference will be to criticise the police officers' decisions, not to provide statements regarding their involvement. And it would appear that a copy of the draft document was sent via PIRC to the police. I suppose at a basic level the question is, why were PIRC doing that?
What's the draft document?
The draft document is a draft copy of a press statement by Mr Anwar given to Mr McSporran. So Mr Anwar appears to be telling Mr McSporran, this is what we propose to do, and Mr McSporran appears to have given that to Mr Little, and Mr Little appears to have given that to the police. The question is why?
Now, was this a matter that was put in the written application?
I don't think so.
Well, why should I consider it then?
I think it is a matter of importance if the inquiry wishes to see whether or not there truly was independence between these bodies, then these sorts of interactions were important. What I can also do, my lord, is I can find out where in the bundle these documents arose, because I've been having to work through some of the tranches as they arrive, and in this more than other parts of the inquiry, that has been an issue, and I have in fact flagged it up in conversation with my learned friend counsel to the inquiry. Just be one moment. In relation to the issue of race, this witness said that he would look for and be aware of officers exhibiting obvious racist sentiments. He said overt racism is one thing, but otherwise it is difficult. And what I want to ask him about was that two police officers had described Mr. Bio as coloured. Keely Good, at page 7, paragraph 5 of PIRC 00274, said that, quote, I made the conclusion that she may have been stabbed. I was also thinking at that point of the Lee Rigby incident in London, mainly due to the fact of the coloured male and the potential terrorist connotations. And also, Scott Maxwell, PIRC 00267, page 2, paragraph 4 On arrival at the locus, I witnessed a black-coloured male. And what I wish to ask him is whether or not he considered those comments were offensive and of a nature relating to race. Did he consider them racist? And if so, why was this not flagged up with the Crown in particular? Finally, a question in relation to the Health and Safety Executive. This arises from a document COPFS 02430. It's an email from John McSporran from Fiona McNeill of Health and Safety. And it sets out that Fiona McNeill considers that PIRC is the appropriate regulator to investigate this death, but if they become aware of a breach, to bring it to their attention. And the question is, did he go back to PIRC, Fiona McNeill, or anyone, sorry, did he go back to Fiona McNeill or anybody in health and safety with any of the findings? And if not, why not? Those are
These
my
all the
questions.
matters.
Yes.
Thank you. I'll rise to consider these submissions. In relation to the first matter, that's the rationale for Mr. Little telling the police officers about the post-mortem result and their reasons for wanting to know about it. I consider that there is sufficient evidence before me and that that is a matter for submission. I shall refuse that. In relation to the same issue under reference to the evidence of Leslie Bowl, again, I consider there is sufficient evidence and it's a matter for submission. I shall refuse that. In relation to follow-up inquiries, I shall allow Ms. Mitchell to ask about the issue of whether Shekubaya was holding a knife under reference to the Crown Instruction 02781. I shall not allow any of the other matters in the follow-up application as these are all matters for submission. The next item is the Benson email. This matter is already before the inquiry in the statement of Stuart Taylor, SBI 00449, so I will not be assisted by further exploration with this witness. The next item is the issue, or was described as a difficulty, in relation to the three officers who were alleged to have been texting racist remarks. I shall allow questions about what that difficulty was. The next issue is in relation to who told Dr. Shearer about the head injury. It seems to me the important thing was that Dr. Shearer knew about the head injury, and I'm not assisted by exploring who told her. As to the next question, the next issue was the understanding of this witness of what was meant by a cause of death. I think I have more than adequate evidence about that, and it's a matter for submission. The next item related to the media communications, and I shall allow that. The next item related to racist language by officers in statements, that is adequately covered in the evidence and is a matter for submissions. In relation to going back to the Health and Safety Executive, I shall allow that question to be asked. Can we have the witness back now, please? Mitchell. Mr. McSporran, you're going to be asked some questions by Ms. Mitchell, KC, who represents the families of Shekubaya.
Yes,
Ms.
my lord.
Mitchell.
I'm obliged. You have explained to us that you've listened to the evidence of your colleague that gave evidence before you. So some matters that I might raise with you might already have been raised with him, and you might have heard me discuss them with him.
Yes, ma'am.
I want to ask you your view in relation to the changes in evidence from the expression that Mr. Bayo was clearly in possession of a knife when he approached the officers to your understanding as it came to be that he didn't have a knife.
Yes.
And what I would like to ask from you, in the same way as I asked from your colleague before, was, did that not cause you a concern that matters had been stated so positively in a way which showed Mr. Bayo to be a person who was an aggressor, and that then changed to something different? Did that cause you concern?
I don't think it initially caused me concerns because of how it was reported. As I've said, ma'am, when members of the public reporting and seeing Mr. Bayo in the street with a knife, we didn't have accounts from the officers. We know that the officers eventually said that they didn't see the knife in his hands. we had Kevin Nelson telling us that he didn't see the man with a knife. But what we didn't have was the precise details. But by the time I get DC Connell's statement, which I've referenced earlier, the knife was found 30, 40 yards away. And that seemed to throw some doubt on the fact that it was alleged on day one that he had possession of the knife. But I think, as I said, sometimes at the very early stages of these matters, it can be quite a confusing picture, and reports vary. And that's why I say it doesn't immediately cause me concern, but it threw doubt on the initial version presented to us, and that's why when I got to my policy file, come the 5th, which was 2 days later, I did not record the fact that he was in possession of a knife because it cast doubt on it.
I wonder if we can have before us a production number COPFS 02781. Or inquiry number, I should say, not production number. If we can scroll down from this, do we see that is from Alistair MacLeod, and that's to Mr. Little?
Yes, ma'am.
What was requested there from Alistair MacLeod in that first paragraph was related to the issue of possession of a knife. And it says in the second line, as you know, there appears to have been a belief amongst them that Sheikh Abayo was in possession of a knife when he was engaged by the police officers. I would like to try and ascertain where their information came from. And there are further questions added. And then if we just scroll through briefly, I won't go through them, a job has been done assessing the evidence of the witnesses and asking further questions and also identifying various issues that wanted to be dealt with. Now, what I would like to ask from you was, were you involved in the inquiries to try and ascertain how it came to be that the phrase clearly in a possession of a knife came to be?
No, I think possibly Mr. Harrow or Mr. Little, which was day one and day two, would have been better placed to answer that, because come day three, I had doubts about that due to the position where the knife was found.
Now, this email is dated 11th December 2017, so that's of course clearly a considerable period of time after, some 18 months or so after the date, and inquiries were caused to be made by that time by the Crown via the PIRC. What were the outcome of those inquiries?
I think Mr. MacLeod was pre-nosing some of the witnesses, and therefore when these things were thrown up, he asked us these additional questions. Now, come December 2017, I'd previously that year taken over as head of investigation, so at that point Mr. Little had become the person in charge of the investigation. I don't specifically remember this email.
But you were still involved with the inquiry
Yes,
at this
ma'am.
time?
Yes.
So are you telling us that you don't know what the outcome of those inquiries were?
No, I think it was clear that we knew by this stage, clearly knew by this stage, that Mr. Abayo did not have possession of the knife when he confronted the police officers.
Indeed, but with respect, I think the question that was posed by the Crown for PIRC to answer is, and it says in terms, I would like to try and ascertain where that information came from. So it was well known, even by early days, as you have already said, that it wasn't correct.
Yes.
They were asking you to investigate a different question, which was where that information came from. Are you saying to that inquiry that you cannot remember the outcome of those inquiries?
I don't remember that, ma'am, sorry.
Do you remember if the senior police officers were interviewed in respect of that?
Yes, certainly there was statements taken from Gary McEwen, from Detective Superintendent Pat Campbell, What the basis was for on day one saying he was clearly in possession of a knife, I don't know.
And
But by day 3, I had my doubts about that.
and to this inquiry at the moment, you still don't know the outcome of the request by the Crown to ascertain who that had come from.
No, I think that was Billy Little that undertook those inquiries.
In relation to the issue of race, you discussed with the inquiry the WhatsApp messages between 3 police officers. And those police officers, I think you used the phraseology sacked. I think they were required.
Required to resign before being dismissed, I think is the official term. Or required to resign, it's something like, or be dismissed.
Yes, I think it is an alternative.
Yes.
And
I think I was just using the colloquial expression sacked.
Indeed. I make nothing of it. I'm just clarifying that issue really before I go on. In the documentation that we have seen for this inquiry, there appeared to be a difficulty which arose in the investigation that you were doing to try and ascertain whether or not there was communication or contact between these 3 officers who had been found to exhibit racist beliefs in their WhatsApp messages and the officers in question. Can you explain to the inquiry what those difficulties were and how, if possible, they were resolved?
Yes, well, initially we had asked Police Scotland for copies of the downloads of the 3 officers' phones, and Police Scotland initially refused to provide them to us. But we were aware they were reporting these matters to Crown, so we approached Crown to break the deadlock, and we did eventually get those phone records, which were very extensive, as I mentioned. One of them was 27,000 pages, so that's how we broke the deadlock.
And have you, can you give the inquiry an understanding of how long that took to break that deadlock?
I think it was several weeks, because Police Scotland considered that they were doing a criminal investigation, their own criminal investigation into the actions of the officers, and therefore they couldn't release that material to us for another purpose, which was the death investigation. But they were reporting to Crown, so Crown eventually unblocked or released the deadlock.
The Crown also asked you to identify whether or not there was contact between the police officers. It wasn't just digital informed. Do you recall that?
Yes.
And was that those investigations carried out by yourselves or your
So
colleagues?
we had the officers' telephone numbers. That's the 9 principal officers, and we went through 27,000 pages to see whether any of the officers' telephone numbers appeared in the 3 officers who had been dismissed. And they didn't.
I was thinking more about, rather than a digital communication, if there were contact with them in person, you know, they worked together in shifts, etc. Was that something that the Crown asked you to investigate?
We did look at that, and they didn't work on the same shifts or in the same department in relation to a couple of them as the 9 principal officers. I think 2 of the officers, 2 of the 3 worked in the CID, and the other one that I knew definitely didn't work in the same shift as the 9 officers. I can't remember now exactly where he worked, but we did examine that.
Okay. Moving on, I would like to consider an issue that you raised earlier in your evidence in relation to media reporting. And you use a phrase that it wasn't your job, or perhaps the job of PIRC more broadly, to referee the opposing factions. Do you recall?
I recall using that
You
phrase.
recall using that phrase. Now, do you recall meeting with Mr. Anwar relatively early on in the process of this inquiry? And by that I mean the 13th of May, where he gave you a copy of a press release that was due to be coming out the next day?
I do recall meeting him. I can't recall him handing me the press release, but I fully accept if he says it did, then it would have happened.
Okay. Well, we have evidence before this inquiry of a document. I have now found that document number, although it won't be available to be brought up on screen, but the document number is PS 04984. Now, this is a document from William Little, so not from yourself, but from William Little. It was sent on the 14th of May, and it related to what is described as a family press conference. And the importance was described as high. And this was sent to Keith Hardy and Stuart Wilson. Those are both officers from Police Scotland, is that correct?
Yes.
The email is very short. I'll read it out to you. It reads, "Morning, Keith / Stuart. The PIRC was made aware of this late yesterday afternoon. John McSporran spoke to Mr. Anwar late last night, and it would appear that the thrust of this conference," and that means a press conference
Yes.
a later day, "will be to criticise the police officer's decision not to provide statements regarding their involvement." And then further on in that document is a press release dated Wednesday the 13th of May. And it says press conference Thursday 14th May 2015. And indeed it does go on to raise some of the points that were said there.
Yes, ma'am.
Does it jog your memory that you had that conversation with Mr. Anwar about this?
I knew he was holding a press conference. As I say, I can't remember, but I fully accept that if he'd hand me a copy of that press release, I would have accepted it, of course.
Well, it certainly seems somehow, either by you having a meeting with him, and that's what the email tends to suggest, or by somehow Mr. Little has a copy of this document. Can you explain to me why that document might be passed from PIRC to the police, advising them of this issue of criticism?
I think we shared press releases with Police Scotland. The specific thrust of your question is, why did we share this where it appeared that Mr. Anwar was going to criticise the police? Again, I can't recall. I think the challenge was at that time we were looking for DCI Hardy, who was taking action on our behalf, to try and obtain the statements from the officers. The exact thrust of why we shared that, I can't recall now, sorry.
In retrospect, do you think it was appropriate that you shared that document?
I think I'll let the inquiry be the judge of that.
You mentioned something in that response that I'd like to check with you. You said that you think that you showed the Police Scotland your press releases. Is that correct?
What happens is, if we're doing press releases in relation to a Crown-directed investigation, we've run it by Crown in the first instance. We also share it with Police Scotland because they might also be undertaking aspects of the investigation, and what you don't want is putting erroneous information into the public domain. If Police Scotland are putting out press releases, they're meant to share it with Crown as well, so Crown have oversight of that and then can agree as to what we put out. Most of the time it is, you've seen it, ma'am, it's very short and direct to the point.
I wonder if it would be possible to have before the inquiry number PS 02751. PS 02751. Nope. Nope, I might have transposed numbers around. I appear to have transposed numbers around. In that case, I'll just explain to you what that document is. The document, which I can't put up on screen, is an email from Gary McEwen, and he is giving instructions to Kate of Media Edinburgh. It's about a proposed media release, and I have in a quote what he says. He says, "This is the proposed media release that will go to PIRC and Crown for approval prior to us releasing it." And what I was wondering was, is that something that you were aware that PIRC was doing? Did PIRC also have a relationship where they reviewed what Police Scotland were putting out before that was sent out?
I think it's more coordinating. The role of Crown is to coordinate. Where you've got PIRC and Police Scotland doing aspects of the investigation, you know, I mean, the legislation says we shouldn't be releasing information without the approval of Crown. We operate, or PIRC operates differently from the police. But in relation to an investigation that the police know that PIRC are undertaking, it should be coordinated. Not necessarily, it's not for people to agree. I mean, the police can choose to put out their own version of events, but that should be cleared with Crown. It's different when the police are the sole investigative body, and we've all seen it where they're doing, if there's a murder, they're potentially doing press conferences, witness appeals, all that sort of stuff. But in PIRC death investigations, everything we put out has to be cleared through Crown.
Okay. Really, I understand that, but what I was more interested was in Gary McEwen saying the proposed media release that will go to PIRC and Crown for approval. But are you suggesting that it's not approval that's being required?
It's not for PIRC to approve it, it is for Crown to approve it.
I wonder if I might then move on to an issue that you were speaking about in relation to race. And you talked about overt racism and that being easier to spot than racism about views people hold, but they might not express those directly, and therefore that might be difficult to understand. And what you identified was that if there was something obvious or something that was important in relation to race, you would flag that up with Crown Office.
Yes, ma'am.
If you came across that. Now, in this particular hearing, we have heard evidence that two of the police officers who were there on that day, that being PC Cayley Good and also Officer Scott Maxwell, said phrases which could be deemed offensive and of a race nature.
I know what you're referring to, ma'am.
Can you tell me what I'm referring to?
It's because they use the word coloured in their statements.
Yes.
As opposed to black.
Indeed. Why, in those circumstances, when those phrases were used, did you not then report that particular matter to the Crown?
We did report that matter to the Crown because we shared the statements with Crown. Excuse me, frog. But we didn't, in the initial phase of the investigation, obviously it was the 4th of June before we got the officer's statements. And we thereafter shared the statements and other material with Crown, and we were constantly briefing them. So Crown would be able to pick that up within the statements.
I suppose my question is this: why would it be for Crown to pick it up, and why wouldn't it be for PIRC to say, we've read these statements, there appear to be racially offensive terms in two of these statements, and we're flagging that up as an issue of race to you, as opposed to just submitting these things and letting the Crown decide? What was PIRC's job to look at that evidence and assess it and bring that to the attention of the Crown?
I'm having some difficulty with directly answering that, ma'am, and I think the reason is that we were overwhelmed with information. We had information overload in the first several weeks of these matters. Did we immediately pick that up? I think the potential answer to your question is we failed to spot that, and that was an error. We should have spotted it. I'd read all the statements several times, and I failed to spot it, and that was an error on my part. So potentially I should have done more there, and I apologise.
Moving on, can I ask you about an issue arising from health and safety?
Yes, ma'am.
I don't have the document to bring before it, but you'll be happy to hear. I'll just give you the details of it. It's COPFS 02430. This is an email to you from Fiona McNeill. Do you remember having interactions with her, correspondence with her?
As Fiona McNeill was the HSE?
She was indeed.
Yes, I do.
Yes. Now, in this email, it states that that PIRC, that the HSE considered, or is content, was in fact the phrase used, that PIRC is the appropriate regulator to investigate this death, but should you become aware of a breach, and that's a breach of HSE, in fact section 3 was referred to at an earlier stage, but it just says there, a breach. Should you become aware of a breach, bring it to our attention.
Yes, ma'am.
And my question is, when you looked at all the evidence before you, was there anything that you saw from the statements of the officers, the statements of the civilian witnesses, the Snapchat, what you know of restraint? Was there anything in that that made you think, I should go back to Fiona McNeill and I should raise these issues with her to consider?
No, but then again, I think Crown would be the safety net there, that once they considered that, if they thought that the HSE should take further action, they could have done so. I didn't consider, following my discussion with Fiona McNeill, that I think the problem is my expertise in the field of health and safety legislation is not what it should be. I lack expertise in that area, and therefore I'm falling back on Crown to pick something up, and they could refer to the HSE.
Did you flag that up with Crown, that you didn't have that expertise, or that you...
Crown were certainly well aware that we were engaging with the HSE, and we cannot undertake investigation into HSE matters, and Crown were well aware of that. Consequently, we would collect the evidence and submit it to Crown.
You see, what I'm concerned about is, you say Crown were well aware that you were interacting with HSE, but what I'm concerned about was that if Crown thought you were interacting with health and safety had written to you saying that PIRC is HSE is content that PIRC's the appropriate regulator to investigate, but should you become aware of a breach, bring it to our attention, that in that mix, the question of whether or not there has been a breach of health and safety regulations has not been properly considered by the appropriate body.
I know it's Miss McNeill's opinion that we're the appropriate body, but we're the appropriate body to investigate the death. We cannot be the appropriate body to investigate health and safety matters. I fall back on what I've said already. The safety net there is Crown, who can receive this, and if they think action should be taken by HSE, they can do so, and they have done so in other PIRC investigations.
I suppose I understand what you say about your area of expertise not being health and safety, but these are, of course, criminal allegations. And what you had before you was evidence of, in particular, I'm talking about restraint, behaviour that may have been a breach of of Section 3. Did that cross your mind at all, that information might trigger?
No, ma'am. because it was never a criminal allegation from my mind that the actions of the officers crossed into the area of criminality. And as I think I mentioned the last time I was giving my evidence, ultimately the Lord Advocate considered all these matters and considered that there was no criminality on the part of the officers.
I'm obliged.
Thank you. Mr. McSporran, thank you very much for coming to give evidence to the inquiry. I'm very grateful for your time over a 3-day period. Inquiry is about to rise for the day and you will then be free to go.
Thank you, my lord.
We'll adjourn until tomorrow.